What is the legal definition of acceptance? When is acceptance actually recognized as a counter offer and is silence recognized as acceptance? In this video, we will discuss the acceptance as the second video in our 6-part series that aims to answer the question of what makes a contract legally binding. Make sure to stay until the end of the video to find out whether acceptance needs to be in writing. If you're new, I'm Malcolm Zoppi, an English qualified solicitor and the managing director of Zoppi, my law firm. And on YouTube, my goal is to make business law easy. Amazing. So what is acceptance? The law doesn't actually define the exact words that must be used to recognize an acceptance as a legally binding acceptance. Instead, we look at the reasonableness test. And that is whereby, so does a reasonable person believe that that person who received the offer has accepted the offer? That is the reasonableness test. In this case, that means that acceptance must be analyzed on a case-by-case basis. One thing is certain though, that if you believe to be accepting an offer, but instead you're varying the terms of the offer that was made to you, instead of accepting, instead you are countering offering against that offer. Offers can be accepted by conduct. So for example, if someone makes you an offer and you don't say anything, but you start acting as if you had accepted the offer by, for example, starting to fulfill some of your obligations under the contract, then you might be recognized as someone who has accepted the offer in a legal way. Thumbs up emojis or any emoji that could be recognized as an acceptance do qualify and are recognized as acceptance of offers. Silence typically is not recognized as acceptance unless, for example, the two parties have a history of accepting offers by silence. Another cool thing to know about acceptance is that if you accept an offer by sending a letter via the post, the moment that you post that acceptance is the moment that you accepted the offer. That is regardless of whether that post actually makes it to the offeror, so the person who made you that offer. That is known as the postal rule. Now, before we move on to discussing whether acceptance or a contract overall needs to be in writing, make sure to subscribe to my channel to continue to receive to the point, pragmatic and practical legal information. Also, if you're interested in a free legal advice call, make sure to reach out. I have my contact details below. Acceptance, as we discussed, can be by conduct and even by silence in certain circumstances. So it does mean that it does not need to be in writing. Contracts overall don't need to be in writing typically. For example, you have verbal contracts between parties all the time. Great, so in this video and in our last video, we discussed the offer and the acceptance. And you believe that maybe that is sufficient to create a legally binding contract, but you'd be wrong. We actually need real consideration to be offered as part of the deal. So to learn more about consideration, make sure to watch this video right here.